Hi, this is Josh Blackman. I'm the president of the Harlan Institute. It's my honor to welcome you to the 2025 Harlan Institute Virtual Supreme Court competition. This is our round of 10, and we have two semifinalist teams who are advancing. So first we have team number 19837, Nathaniel Marks and Edward Napoli from Regis High School in New York. And the respondent team will be team number 20129, Annika Grote and Lee Snyder from Westminster Christian Academy, Missouri. Petition begin whenever you're ready.
Mr. Chief Justice, and may it please the court. I'm Nathaniel Marks.
And I'm Edward Napoli, together representing the Petitioners Free Speech Coalition.
The court should hold that Texas Bill 1181 should be examined under strict scrutiny, or failing that, under intermediate scrutiny. Respondents' arguments in favor of examining the bill under rational basis scrutiny fail.
The bill applies specifically to pornography and content that adults should have a right to access, which is a form of content-based discrimination. The bill violates the rules outlined by this court in Ashcroft by applying vaguely defined community standards, thereby restricting the right of adults to access adult content. By restricting the rights of adults to access the content, the bill is in violation of both Reno and Playboy Entertainment.
If the court does not apply strict scrutiny, it should apply intermediate scrutiny. This bill regulates the manner in which adults are able to access adult content, and in fact closes off some of their avenues to access said content. Because this bill is a time, place, and manner restriction that closes off alternative methods of communication, this bill should be examined under, at the very least, intermediate scrutiny.
The arguments in favor of applying rational basis scrutiny fail. Petitioners say that adults have no right to access this adult content, but this court has repeatedly held in cases like Ashcroft that there is a First Amendment right to view such content, especially when broad definitions like contemporary community standards are used. Petitioners also argue that age verification methods are examined under rational basis scrutiny, but that's only the case when only minors are impacted, which is not the situation here.
Because this bill discriminates on the basis of content and violates the rights of adults, strict scrutiny should be applied. At worst, because this bill is a time, place, and manner restriction, intermediate scrutiny should be applied. Petitioners' arguments in favor of rational basis scrutiny fall flat. We therefore ask the court to reverse the judgment of the Fifth Circuit. We welcome the court's questions.
Well, I appreciate that you say for your last 5 seconds that the argument for rational basis falls flat. I think that's that's really that's what I want to hear about the most. You didn't mention Ginsburg, so why isn't this case simply a 21st century version of Ginsburg?
Well, Your Honor, the thing about Ginsburg is that Ginsburg had a conditional almost. It held that the age identification was valid because adults were not impacted by it, because it was easy for adults to present their ID to a clerk or whomever was buying or whoever was.
I mean, I read Ginsburg some time ago, maybe I don't remember. Where does it say that in the case?
Your Honor, I don't have the quote in front of me right now. It's somewhere in our brief. I wish I could find it for you right now. But
as a conditional, is that what they said?
Not so much a conditional, but it framed it as because only minors are being impacted by this age verification because it was easy for adults to present age identification. Their rights were not being violated, and because adults.
Right. So the fact that was the case that they said it was so easy for adults to present ID, that was part of the analysis.
It wasn't part of the meat of the case says that this age verification is okay. But the case says that because adults are not being impacted, that's part of what makes it okay. In this case.
Yeah, and I just wonder, and I appreciate I'll let your friend take an answer. It's very often the case we read a decision from half a century ago, and we sort of see things there that weren't actually said. So, I mean, did the court say this stuff, or was it implied? I mean, it's an important press. I want to make sure we understand it carefully.
Well, Your Honor, I can answer that. Please. And we do think that the court did make it very clear that one of the main reasons why precedent from Ginsburg was upheld there was because of the nature of the case being that of a brick and mortar store, where the owner of the store, which was providing magazines where some of them did display pornographic content, there was no sort of limitation on the fact that he was able to sell these magazines with this content to customers who were over 17 years of age or older, which I think was explicitly said.
So the court in
I want to go back to the burden though. I mean, what exactly, assuming that an adult in Texas provides the ID, he gets what he wants right away. I mean, there's not like a burden. I'm still trying to see what exactly is the burden that you're so concerned about.
Well, Your Honor, we think that the burden in this case, and one of the main differentiators from Ginsburg, is that in the case of Ginsburg, what you could provide as an identification would be something like an age verification method, which you show to the cashier, and that's a minimal sort of burden on the customer. But in Texas Bill 1181, it specifically mentions three forms of identification, one being a government identification, a commercial license similar to maybe a mortgage
How's
application,
that
or
different than the
some form
clerk?
of
How's that different than the clerk? You're showing government ID. I mean, it seems pretty similar to me.
Well, Your Honor, the thing about this is that because it's a digital world, because there are unique risks that are posed by digital data collection, risks like fraud, risks like collection, even though this bill says that data shouldn't be collected, there's no guarantee of that because it's online.
So you're okay just showing a person a license, but you're not okay with putting on a cloud somewhere. Is that your position?
Well, Your Honor, that is, we think, a valid position to hold, that showing someone a license is a very minimal burden on
But
that
let's
person.
say let me change this, right? Let's say if a person in Texas wants to get into pornography, Texas passed a law that says, okay, go into the DMV, show your license, it'll give you a porn card. And this will let you get access as much as you want. And that way, the information never goes into Pornhub's servers. You go right to the DMV, you show your license, they give you a card, and then you use that to get stuff on the internet. Would that be okay?
Well, Your Honor, there are other factors at play here. So if the ability of adults to,
I asked a yes or no question. I mean, would that be okay?
unfortunately, Your Honor, there are other factors at play here aside from just the brick and mortar store. So one of the issues that is
But
posed by
that's my point. I'm trying to look at a question. How do you do internet age verification with internet pornography if you don't have some form of ID being presented? I think going to the DMV is a heck of a lot more burdensome than going to a website and clicking a few buttons. I don't I mean, you seem to see out of proportion. You're objecting to the wrong thing. Texas tried to make it easy for you.
Well, Your Honor, we do think that there would be other methods to filter this content for minors that would likely be more effective. I know there were methods.
I know you think there's other things that are more effective. I got that. I understand that. But I'm saying if Texas says the only way of saving this is age verification, isn't the system they have now, which is used for gambling and other sites, isn't that the least restrictive way to have a least burdensome way?
Well, Your Honor, we think because of the speech nature of the content that's being restricted here, you need some form of filtration other than what's been used to apply to sites such as gambling sites, because that content on those sites isn't protected speech of the same nature. So while it might be, I guess, less burdensome for someone to click a button on one of these applications as a filtration method, due to the nature of the content that's actually being filtered and that being protected speech, it does require some other form than what's been used previously.
Okay, we'll proceed.
Well, Your Honor, just to look at Ginsburg again, Ginsburg said that because the law in question did not bar the defendant from distributing adult content to persons 17 years of age or older, the law did not run afoul of the First Amendment, because the court has held that when alternative methods or when methods of access for this kind of content are not closed off, when children are blocked from accessing content, but adults are not, that's where you have restrictions be valid.
Mhm.
However, in this case, adults are blocked functionally from accessing this content. After Texas's bill was passed, websites like Pornhub, which is the world's largest distributor of adult content, closed their availability to adults in the state of Texas.
Mhm.
And when you saw similar bills proposed across southern states,
Counselor, is this a facial challenge or is it an as-applied challenge?
Your Honor, I believe that this is a facial challenge.
So do we really even care what happened after that? Shouldn't we be just judging the statute on its face? Do we really care how it applies to Pornhub? Does that really matter here?
Well, Your Honor, what happened to Pornhub is a result of the content of this
I know,
outlet.
but when we do a facial challenge, are we looking at the face of the statute? Do we really think about the actual consequences?
While it's true that the consequences aren't as important in a facial challenge, the consequences are integral to examining how the content on the bill, in the bill on its face actually works. When you look at Ginsburg, when you look at Ashcroft, when you look at similar cases, the reason why they worked or didn't work is because they either allowed adults to access this content, which made them work, or didn't. And that's an inherent part of how this goes. This is when adults are able to access this content, then you don't see a restriction of liberties, then you don't see a violation of the First Amendment. Because you see a restriction of the ability of adults to access this content, then you see a violation of the First Amendment.
Okay, very good. Thank you, Counselor. All right, respondents, 15 minutes, whenever you're ready.
Mr. Chief Justice, may it please the court. I'm Annika Grote.
And I'm Elise Snyder.
We are representing Paxton, the respondent. In 2023, a bill was passed in Texas that restricted access to sexual...
We're familiar with the facts. You can proceed with the argument.
Okay. Texas House Bill 1181 implements age-based moderation, not content-based moderation. While content-based moderation would be a violation of multiple parties' First Amendment rights and invoke strict scrutiny, as shown by Playboy and Reno, age-based moderation does not burden any party's fundamental rights. Under Ginsburg versus New York, rational basis review should be applied in the case of age-based moderation.
Some of the content that falls under HB 1181 is considered obscene. While HB 1181 does not deal with the nature of the content because it is not a content-based moderation, obscenity, which is determined by the Miller test, is not constitutionally protected form of speech. And Harlan versus United States stated that the regulation of obscenity does not impose strict scrutiny.
Furthermore, content that is not obscene but considered sexually harmful to minors is prohibited for minors, as well as other material on sites with more than 1/3 of their content being sexually harmful. All these factors call for rational basis review, not strict scrutiny. This court should side with the respondent and review this law under rational basis scrutiny.
We welcome the court's questions.
All right, I'll start with sort of the mirror image. I mean, you're, of course, leading off with Ginsburg. How do you view this case under Playboy and Reno? It seems that you have pretty clearly a content-based restriction that these restrictions are triggered based on having a certain percentage of pornography. How do you get around those precedents?
Your Honor, for Playboy, the court struck down the law that sexually oriented programs would be prohibited from being shown on cable channels during certain hours. And because this law is a clear example of content-based moderation, it tells the companies they cannot show certain channels or display their contents. In HB 1181, it is an age-based moderation, so it doesn't restrict Pornhub or other.
But I want to just focus on this point. I agree. There's age-based components here, right? I'm with you. But what triggers this law is that a certain percentage of videos or content must be pornographic. And if so, then these restrictions apply. Isn't that a restriction based on the content? In other words, I agree, it's not restricting what porn can be displayed, but the restrictions are imposed based on the content. Isn't that a content-based restriction?
I think that the restrictions are imposed, Your Honor. The restrictions are imposed based on the content. However, it is not a content-based restriction. It's just a restriction that is regulated by the percentage of the content because the content itself.
Hold on.
Okay. I'm sorry, Your Honor.
I think you're making your argument cogently, but just to make sure we get the terminology right. So it's not a content-based restriction. It's a restriction based on the percentage of the content.
Yes, Your Honor. The content itself is not being restricted, so it is not a content-based restriction.
You see I'm laughing, right? I mean, it's almost a linguistic game, but this seems very much like a restriction that's based on the content. Even though you're right, you're not restricting the content. Is there any case you can point me to where the substance of the content triggers this restriction, but it's not a content-based restriction? Is there any case you can point me with that?
Well, Your Honor, I think that Ginsburg, as we've been talking about so far, would be a fair example of that, where the content itself was the cause for the restrictions, or for the case, but it was not content. It wasn't like it didn't
Right.
impose. Yeah.
So in Ginsburg, right, the fact they were adult magazines triggered this age verification. But if you had a driver's license, you can then go ahead and get the material. Okay. But I want to now sort of pick up what your friends were asking before. Do you agree there's a difference between showing your ID to a clerk at the corner magazine store versus putting your driver's license in some anonymous cloud where it's going to be seen by China and who knows who else, right? You see a difference there?
Yes, Your Honor, we do see a difference there. In HB 1181, it states that how the age verification system works is you upload it to the website temporarily and they verify it to make sure it is inauthentic.
They. Who's they?
Either the company themselves, so Pornhub, or they can enlist a third-party company to do that.
And is there any sort of, guarantee this won't be leaked into the cloud and sent to China, who knows, wherever it's going to go?
So, yes, Your Honor, within the bill, it states that they are not allowed to maintain the information they use.
I know that, counsel. I know they're not supposed to, but I mean, come on, right? I mean, whenever you put some information in the cloud, it's good as gone. And isn't there a chilling effect of having your license seen by, thousands of people on the internet who don't even know who you are? Isn't that risk always present?
Although, Your Honor, although there could be considered a chilling effect, I do believe within the bill, because it allows you to sue for damages, and receive attorney fees, there should be no chilling effect. Because if somehow your life could be potentially harmed by the bill, you are allowed to sue the company and receive monetary damages. So under those pretenses, because I am protected by the court system and by the law, I would see no chilling effect on speech as referred to in Ashcroft versus ACLU.
So, I mean, let's just even think for a minute about this case. I mean, your friends on the other side said something. They said that after the Texas law went into effect, Pornhub pulled out of the market. They withdrew. And all these other porn sites shut down. You say there's no chilling effect. I say look at the facts on the ground. How do you respond to that?
Well, Your Honor, I believe that this could be an example of how the House bill has done what it set out to do, which is to restrict minors from viewing this content. And regardless of the effect that it had on those companies, minors should not be able to access these websites.
For sure. Your site succeeded in blocking minors, but there's lots of adults in Texas who want to access this content, and they can't because Pornhub withdrew from the marketplace. And Pornhub said, we withdrawn because we're afraid of liability. This is too much. And this is why this lawsuit exists, that people in Texas can't access the content they want to access.
Well, Your Honor, I do not believe that this bill forced Pornhub to withdraw, so it would not be impeding their free.
You're right. You're right about that, but my question is a little bit different.
Okay.
We talk about chilling effects. It's not, is the government making you do something? Is the risk of something so great that you choose not to do it?
Well, Your Honor, something I believe that you stated earlier is that this is a facial examination. So it is an examination of the House bill itself and not the effects that it may cause.
What's the difference between a facial and an as-applied challenge? Can you tell me that?
Well, I mean, Your Honor, I do believe that a facial is strictly examining the content of the law. I'm not quite too sure on the other side of that.
Presume and applied is looking at the effects of actually applying the specific law.
Okay, very good. All right, Council, may I proceed?
Okay, obscenity is not under the category of speech protected by the First Amendment, and HB 1181 does not outlaw any form of protected speech because the sexually harmful material to minors, as stated in HB 1181, is obscenity. So how to determine obscenity? You use the Miller versus California test, which describes obscenity as serious literary.
Yeah.
Dealing with whether or not the material is obscene. I think that we recognize that some of the, everyone recognizes that some of the material on there is obscene as for minors and some of it isn't, but I mean, regardless, you're still preventing adults from accessing things that they have a constitutional right to access. So why is your age verification system the best? Why is this the only thing that the state can do? Or why is this the state's best? Why can't they do content filtering instead? What is your, can you address the petitioner's arguments about content filtering being a more reasonable way to go about the goals that they're trying to accomplish?
Well, Your Honor, if the government were to do a content-based filter, as we've talked about before, it would be a pretty clear violation of the First Amendment. So it'd have to go through strict scrutiny, and then it'd have to be narrowly tailored and a compelling government interest, which it could be. But this way, through age verification, doesn't have to go through strict scrutiny. And we've already seen, even with
the content filtering that they're talking about isn't the content filtering they're talking about is having parents go on to be able to turn on basically a filter for their children. So that way their children can not see this information, but it puts an extra burden on the parents. And I mean, parents aren't really always equipped to be able to handle that interest. And that's why the state decided that they would take upon that interest. And that, so why doesn't content filtering work here? Why isn't that?
Well, Your Honor, I believe that there are a lot of websites that utilize content filtering, especially ones that the parents can implement, such as Instagram. I believe there is a parental feature on that. However, it is not always entirely accurate. And under the House Bill 1181, if the age verification system fails and minors are allowed to gain access to the sexually harmful material, the families are allowed to sue for damages. And so this would make it a lot more effective than simple content filtration.
Yeah, proceed.
Continuing on, within the bill, so Miller versus California outlines obscenity, and it's like serious literary, artistic, political, or scientific value, prurient interest in the view of an average person according to contemporary community standards, and describes sexual conduct or excretory functions offensively. Within House Bill 1181, it is word for word copying exactly what the Miller standard said, which means House Bill 1181, when it is saying sexually harmful material to minors, it is specifically addressing obscenity. And we know under Hamling versus United States that the
Counselor,
regulation.
Let me ask you a question, Counselor. What's the standard for obscenity for minors as opposed to obscenity for adults?
Well, Your Honor, I'm not specifically aware of what the difference is. I know under Prince versus Massachusetts, it gives the states the authority to control children's conduct far beyond their ability to control adults' conduct. And when looking in the context of Ginsburg, we can see that knowingly selling a magazine containing nudity to a minor, so that's even less of a burden than obscenity, was illegal. So I would say, although I'm not familiar with the exact text from the precedent I'm aware of, it would be a much less burden.
Okay, Counselor, proceed.
House Bill 1181 does not fit the criteria for cases where strict scrutiny was previously applied. The petitioner's reply brief states, Texas nevertheless defends the Fifth Circuit's holding that mere rational basis review applies to House Bill 1181's age verification provision because the law aims to regulate the distribution to minors of materials obscene for minors. But if that reasoning were right, then Sable, Playboy, Reno, and Ashcroft would all be wrong because each applied strict scrutiny to regulations that did likewise. It is true that Sable, Playboy, Reno, and Ashcroft had strict scrutiny applied because they burdened First Amendment rights. They utilized content-based restriction that was overbroad and impeded protected.
Can I pause you for a second? I just have one kind of clarification point. This refers back to your previous arguments about whether this is content-based or not. Can you just clarify for me, the threshold is that 30%. If that threshold was significantly lowered and we had a 5% threshold that kickstarted this age verification, would that cause a problem?
Yes, Your Honor, I believe so, because different websites that are forums or social media websites can have pornography and different inappropriate content uploaded to their website, and they have to try to remove it and get it down as quickly as possible. And if they don't get it down, like they're pulling it off, if it rises up to the 5%, then they would be restricted. So that would be too broadly restrictive.
It wouldn't be narrowly tailored enough.
Okay, I take your point, but I am struggling just a little bit on this. It seems kind of arbitrary, the difference between 5% or 30%. Yeah, I'm struggling just a little bit on that.
So, Your Honor, I believe that sites that have 5% of their content being sexually explicit or obscene, harmful to minors, could have that not be their primary, secondary, or even tertiary focus. However, if the content that is sexually explicit or obscene rises to 30%, it would be safe to assume that that is one of the website's main functions.
So, in conclusion, Your Honor, because House Bill 1181 is a age-based moderation, under Ginsburg, we should apply rational.
Okay, very good. All right, thank you, Counselor. 5 minutes response. Go ahead.
Thank you, Your Honor. We would first like to address the issue of content-based moderation versus the age requirement filtration systems. Now, our friends on the other side say that these aren't content-based restrictions, but if the amount of content on these sites that would be considered obscenity or pornographic were to fall to around 5%, then it would be. We're saying that these are actually content-based restrictions because even though it's an age verification requirement, that requirement is inherently based upon whether these sites have a third or more of a specific type of content, which is namely adult content. So clearly these restrictions, though they are based on an age verification basis, are really just rely on the underlying nature of the content.
I think you're trying to answer my question by saying Ginsburg, because Ginsburg, wasn't it that if there was a magazine that was, girly magazine, then you had this age verification? Why isn't this the same as Ginsburg? I mean, I know you say the burden's greater, but that's separate from the classification question, right? Why is this not an age-based classification?
Well, Your Honor, this is an age-based classification. This does specifically apply to content that's 1/3 or more adult contents. That is, as our friends on the other side specifically stated, it's a restriction that's based on content, which we would say is a content-based restriction. And we have argued, and we continue to argue, that Ginsburg is differentiated from this case because in Ginsburg, the ability of adults to access adult content was not restricted, whereas in this case it is. But as we argue in our brief, if this court doesn't apply strict scrutiny, it should at the very least apply intermediate scrutiny, which is more of
I know you said time, place, and manner. What's the precedent you rely on to get to intermediate scrutiny?
well, Your Honor, because this restricts the ability of adults to access content, which is the manner in which they access content. So that would be.
Board counselor might be Pacifica. And so why is this case more analogous to Pacifica than to Ginsburg, where the only difference is that we're dealing with a brick and mortar store versus an online forum?
Well, Your Honor, respectfully, with regard to Pacifica, we don't think that Pacifica is a good analogy for this case, specifically because Pacifica dealt with broadcast airwaves. And as this court has noted, in Red Lion Broadcasting versus FCC, there's a limited number of broadcast airwaves, so the power of the government to regulate speech over said airwaves is greater. We think that probably a more analogous case is Renton, or specifically with regard to speech. Well, yeah, specifically with regard to speech, Renton, because this case limits, unreasonably limits alternative manners of speech and communication. So because it restricts the ability of adults to access adult content in other ways, or even just on these websites in particular, that's restricting the manner in which they're able to access content. So if that's the case, if it is a time and place or manner restriction, which we believe that at the very minimum this bill is, then the court should vacate, remand to the district court as the Solicitor General outlined, and have them choose between intermediate scrutiny and strict scrutiny, and should not apply rational basis scrutiny.
Okay, counsel, let me ask a different direction. If you prevail on this one, Um, let's say the state is not able to actually adopt the other sort of filtering and the other methods. And let's say it turns out that children today are really getting messed up by this content, and that children are evading the filters their parents put on their phone, and that the only thing that could have actually stopped this was the age verification. What should this court do if all these children have severe mental health conditions because of this proliferation of this pernicious pornography, proliferation of pernicious pornography, it's proliferation? What are we to do?
I'm sorry, Andrew, could you repeat the core of that question? I'm sorry, a school bell just went off and we couldn't
That's
quite
no,
hear.
hold on, oh, that's a terrible excuse. Okay, fine. Proliferation of pernicious pornography. What do we do with this? In other words, how do we save the children if the only way they can do this is with age verification?
Well, Your Honor, we don't believe that hypothetical to be the case. In that hypothetical world,
You're fighting my hypos. I'm telling you, this is the hypothetical. No, that's what's hypothetical. It's not the case. But please answer it.
well, Your Honor, in that hypothetical world, if this were the absolute only way for the government, if this were the only possible way for the government, or for anyone for that matter, to restrict this content to minors, if this were the only possible way, and I could not emphasize that more, the only possible way for anyone to restrict this content, in that case, it may be valid. But as you said, Your Honor, because that's not the case, because that is a hypothetical, and because there are other efficient ways to restrict that content, we do not think that this is valid.
Okay, very good. Thank you. All right, the case is submitted. Camera off. All right, guys, welcome. That was excellent. I think you can see how harder this was in the previous round. Do you agree? Um, I did a few things a little differently. I'm always trying to be transparent with my students. I interrupted you more. In the early rounds, I'd let you finish your sentence. Here, I didn't quite consciously. At the U.S. Supreme Court, you don't get to finish your sentences. In fact, the best advocates say they try to speak without breathing, because when they take a breath, it gives the justice a chance to come and interrupt. Now, that's not all bad, because believe it or not, the most important thing that's being said is not what's in your mouth, it's what's in the judge's mouth. And often the questions that are being asked are guiding you to what the judge is thinking about. And it's really sometimes more important to listen than to speak. Okay. Number two, when I asked for a yes or no question, I wanted a yes or no answer. And I pushed you on it saying, what's the answer to the question? A couple of times I asked you hypos, and you did something that law students always do. You fight the hypo. Right, Addie? Right, Robbie? Right? Law students love finding hypothetical. They'll say, Your Honor, those aren't the facts we have here. Well, yeah, no kidding. That's what's called hypothetical, right? You're asking hypothetically, you know, how would this issue be resolved if the facts are differently than they are in present? And the hypothetical is a way of sort of seeing what you're willing to accept. And a good hypothetical, I don't know if mine were good enough, but a good hypothetical sort of pins you down to what's basically a yes or no. There's going to be one final yes or no. And if you say yes, the case sort of curves one way. And if you say no, the case curves the other way. And the challenge for you is how to answer the yes or no hypothetical without messing your case up, without giving yourself a very tough time. So it's not easy. I think a couple of you had the instinct of saying, well, maybe it depends and so on. You might get away with it, and you can try, but expect, I think, the judge to push you back and to challenge whether, in fact, you've answered the question or not. All right. In terms of the sort of the individualized feedback, I think both teams are very strong. You're calm, you're collected. I saw no flusters. There was no like you were very there. As I just say you're better than me. I'm not. I just play a lawyer on TV. I think that I need to see less reading. I saw a lot of reading from papers. I know I know when you're reading. I don't want to see that. That's not good. I mean, it's not bad, but you should have. I'm asking a lot from high school students, but I'm giving you the pro tips if you're law students. Okay, so I need to see less reading. Also, I did this very deliberately. I would ask you a bunch of questions, and I would stop. Say you may proceed. And the sort of the transition back to the actual argumentation is a little bit bumpy because you're a little bit flustered. Like, oh man, where do I go? Where do I start? Um, when I say you may proceed, You can even say something like, well, a moment ago you asked this, I'd like to talk about this some more, right? You can even do that. You don't have to go back to your prepared statements. You don't have to. And in fact, they always say when you prepare for an argument, you have all these things written out, and you probably never say any of them. Right? You have all this stuff ready to go in the can, and it goes out the window the second you get to the court. In other words, after your opening 2 minutes as petitioners, everything goes out the window. Even if you're respondents, especially if you're respondents, you probably will never use your opening material. Your 2 minutes of opening statement for respondents should focus whenever they said they're opening, right? Petitioners. Just throw in the garbage. You start saying, here are the facts of the case. No, don't waste your time with the facts of the case. Start off by challenging what the other side said, and you'll be in such a better spot. You'll be in such a stronger position to contest the issue. Yeah, a couple of times, if you didn't quite get the hypothetical in the first go round, don't fight it. Just embrace it, but find a way to sort of answer it without giving your case away. Let's see. That's what I got. Addie, any comment, Kev?
Y'all both did great. Y'all are incredible. It's really impressive to see high school students arguing, to be honest, beyond the level of a lot of law students. So y'all should be very proud of yourselves. Let's see, things that I noticed. Y'all both had very well phrased responses. Based on Blackman mentioned something good a few moments ago, that like when a judge asks you a question and then just kind of drops you off and stops giving you a hot bench, it's hard to pick back up with what you were saying. A trick that I use often is to just keep talking about what we were just talking about, which is basically what Professor Blackman just told you to do. But I will just keep going and drive the point home really hard and kind of say everything I possibly know on that subject until I remember another tangent and I start going down that tangent. That's what I do. Just that way I basically never stop talking.
Yeah, it's a good tip.
Another thing, I think I heard like a few times, which is fine. I'm saying like now. Probably I would bet I said it 10 times already. It's really hard not to say, especially when you're speaking off the cuff, because it's just something that we naturally say. But when you're the one listening, you can hear it more, which is crazy. And it's not really a big criticism, but some judges don't like it. So just pay attention to that in the future and be very aware of the words coming out of your mouth. It's very hard to do, so don't worry about that. Y'all are both very confident, as Professor Blackman mentioned, and you seem to know your stuff. Judges will try to ask you to pull out quotes from cases, basically.
Yeah.
They want you to, because they want you to give them a reason to, they want you to have a really good argument against them. Like when a judge is asking you questions, it's in real life, it's because they want you to give them a good answer, So think of the questions as an opportunity for you to like educate the judge. Not just I don't think either of y'all were like felt arguing with the judge, which is pretty good because I used to do that on a hot bench. I would start arguing back with them and get a little feisty. But they're doing it because they want to give you an opportunity to say the right thing. So think of it that way. And yeah, I thought y'all did a great job. That's pretty much all I have to add.
Yeah, Robbie?
Nothing too much. One of the main pieces of advice I've gotten over the past year has been, to the extent you're able to, treat this as a conversation. What Professor Blackman mentioned that the reading earlier. One of the things, it's not just that like your eyes are looking down, but it's also just a little less conversational. And I think the strongest points of both of y'all's arguments were when you were kind of going off the cuff. That's what felt the best and what was the most interesting.
Yeah.
That's the main piece of advice I have, that the notes are hurting you more than helping.
Yeah, I think that's right. The judges know when you're being spontaneous and when you're reading or at least even reciting from memory. There's a very subtle difference in how you engage with the bench, and I think you have to sort of think about how to become more fluid with your argumentation. You're all very natural, but it still felt like you were arguing. It didn't feel like Robbie's like a conversation at times. And if you look at the best advocates, look at a Paul Clement or Elisa Blatt or like, these people, or Elizabeth Prelogger, they're having a friendly, respectful, sometimes edgy conversation with the justices. It's really a thing of beauty. Go listen to the best advocates. It really sounds like they're just friends. They're hanging out and they're talking, even though the judges are up here and they're down there. Actually, if you ever go to the Supreme Court, it's actually pretty close. There's maybe 5 feet distance between the bench and the podium, and they're not that high up. It's actually it's surprisingly close, the dynamics. Um, uh, but you have to make it just seem a little bit more natural. That'd be the only thing I would say to Robbie's point. Yes.
Do you all have any questions for us?
I don't think so.
Any questions about law school? Anything in general in your minds?
Y'all should go to Texas College of Law.
One down. Love to have you as a student.
Whatever he says.
Oh, UNC, wherever that is. What's UNC? I don't know what UNC is. All right, anything else, guys? If not, we'll stand in recess.
I don't believe so.
All right, thank you all so much. I enjoy all of your companies, and I learn a lot from you all, and I'm so grateful you do this. I know this is hard work, but hopefully this will be advice that will serve you all for years to come. All right, thank you.
Thank
Thank
you.
you.
Thank
Thank
you.
you.